Imagine you are a senior partner at, one of the top tier law firms in the world.
Right.
You just went to your managing committee and convinced them to pay a vendor literally millions of dollars for this brand new state-of-the-art generative AI tool.
A massive investment.
Huge. And the promise is that it's going to save thousands of hours, boost your margins, and basically do the heavy lifting of a dozen junior associates, right?
That's the pitch.
Right, that's the pitch. So you deploy it, your team uses it to draft this critical brief for federal court, you submit it, feeling like an absolute pioneer of the digital age.
And then reality hits.
Yeah. And your reward is an $86,000 sanction from a very, very angry federal judge who publicly humiliates you because your shiny multi-million-dollar AI literally hallucinated a court case out of thin air.
I mean, it is the ultimate professional nightmare.
Completely career-ending.
Potentially, yeah. And the terrifying thing is that it's not just a hypothetical. That exact scenario is playing out in courts right now.
It's wild. Welcome to this Innovation Unpacked deep dive, everyone. If you're joining us today, whether you're, commuting, prepping for a board meeting, or just insanely curious about where the tech world is actually heading, buckle up.
It's going to be a big one.
Today, we are unpacking a massively comprehensive dossier. It's the Venture-Proof Analysis by Mike Boysen.
A really fascinating piece of work.
It really is. It completely deconstructs the explosive, chaotic, and I think heavily misunderstood rise of legal generative AI. And we are putting one company specifically under the microscope today, which is Harvey AI.
And we really need to ground the stakes right at the top for you, the listener, because they are just astronomical.
Oh, yeah.
We aren't just talking about, a cool new chatbot that can write a decent contract clause. We are talking about an entire global sector in total transition.
Let's talk about the size of that sector.
Right. So the foundational total addressable market, the TAM for legal AI, is sitting at roughly $10.82 billion today.
Which is already massive.
It is, but the projections, they show this skyrocketing to a staggering $156 billion globally by the early 2030s.
Wow.
The scale of capital moving into the space is just historic.
Historic is exactly the word. I mean, look at Harvey AI itself. They hit $300 million in annual recurring revenue, and they secured an $11 billion valuation in under 4 years.
Under 4 years?
Under 4 years. That kind of hypergrowth is just, it's breathtaking. It's the ultimate success story of the AI boom, right? Because we were promised generative AI would destroy the billable hour, replace junior lawyers, hollow out the big firms, and make everything frictionless.
Right, right.
And looking at those top-line numbers, it feels like that's exactly what's happening.
Okay, I hear your excitement, but I really have to stop you right there.
Oh, come on, $11 billion.
Yes, the top-line numbers are breathtaking. But the premise of this entire dossier, the reason we are doing this deep dive, is that those top-line numbers are an illusion.
An illusion.
This valuation is highly speculative. In fact, it might be a pure bubble. Generative AI hasn't destroyed the billable hour.
It hasn't.
No. Instead, it has created a massive labor bottleneck. It is exploding IT budgets, and the actual value in the market is shifting entirely away from the AI models themselves.
Wait. Away from the models. But everyone is obsessed with the models. The whole tech industry is about the models.
Exactly. But the venture-proof analysis exposes a massive hidden operational friction lying just beneath the surface of all these enterprise deployments.
Okay.
The real value is moving toward an obscure, hyper-technical concept called citation provenance. And if the industry doesn't fix the underlying friction, this whole $11 billion house of cards could just come crashing down.
Okay, let's unpack this, because to understand the crash risk, we have to understand the climb.
Right.
Let's take you back for a little historical context. So Harvey AI, which is officially named Counsel AI Corporation, was founded in late 2022. They get a $5 million seed round from the OpenAI Startup Fund. And that is a crucial detail, right?
Right. It is the defining detail of their early success.
Because it wasn't just cash.
No, getting that seed money from OpenAI meant they got early inside access to GPT-4 before the rest of the market even knew what it was. Yeah. They had a foundational head start on the underlying intelligence.
Right. So by 2023, they parlay that head start into an exclusive partnership with Allen & Overy.
A massive firm.
Huge. That puts the tool directly into the hands of 3,500 elite lawyers. And boom, they end 2023 with $10 million in ARR.
It's the classic early adopter acceleration phase. It's textbook, but the dossier pinpoints 2024 as the definitive stall point.
Okay, hold on. Stall point. I'm looking at the data from the dossier, and it says they hit a 400% year-over-year growth rate in 2024.
Right.
They reached somewhere between $50 and $65.8 million in ARR. They secured contracts with 42% of the AmLaw 100, which, for those outside the legal sphere, is the list of the 100 highest-grossing law firms in the United States, capturing 42% of the absolute elite firms in 1 year. That sounds like absolute market dominance, not a stall point.
It sounds like dominance, I grant you that, but you have to look at the psychology of why those firms were buying.
Okay, why were they buying?
That 400% growth wasn't necessarily driven by a careful, calculated return on investment.
No.
No, it was driven purely by FOMO, the fear of missing out.
Oh, interesting.
You had managing partners at elite AmLaw 100 firms who were utterly terrified of disruption. They saw the headlines, they saw the competitors signing up, and they panicked.
So they just bought it to say they had it.
Exactly.
Yeah.
They were signing blind, locking themselves into these opaque, wildly expensive, seat-based SaaS contracts.
And when you say SaaS, you mean software as a service, right?
Exactly. Traditional subscription software. But these weren't cheap subscriptions. They were paying $1,000 to $1,200 per user annually. Harvey was capturing the absolute lowest hanging fruit in the market, the firms with massive innovation budgets who could afford to throw millions of dollars at an experiment just so they could put out a press release saying, hey, look, we use AI.
Ah, so it was a defensive play by the law firms, a PR play.
Entirely defensive. But here's the problem. Once you capture the AmLaw 100, you hit a structural ceiling.
Because there's only 100 of them.
Exactly. You run out of elite firms with bottomless R&D budgets. The data in the dossier is incredibly clear on this slowdown. Despite absolute revenue continuing to climb, the percentage growth decelerated dramatically.
Oh, dramatically.
It dropped from that 400% high down to 290% in 2025, and the dossier estimates it plummets to a mere 53.8% by mid-2026.
So they exhausted the elite tier, and now they have to sell to the mid-market.
Exactly, and the mid-market is highly price-sensitive.
Right, they can't just throw money around.
A 50-person regional law firm isn't going to buy $1 million SaaS package out of FOMO. They demand actual proven ROI. They need the tool to actually work efficiently without hidden costs.
Okay, but, and I'm thinking deeply about this, even with that severe deceleration in growth percentage, they just raised money at an $11 billion valuation.
Yes.
I mean, I don't care how much FOMO there is, you don't get an $11 billion valuation from top-tier venture capitalists without serious fundamental belief in the product.
Right. Well, here is where the dossier drops a massive speculative bombshell. Let's do the math on that $11 billion valuation. Based on their revenue, that represents a 36x to 57x revenue multiple.
57 times revenue. That is steep.
In standard SaaS fundamentals, that is absurdly disconnected from reality.
What is normal, like 10x?
Yeah, a healthy, high-growth public SaaS company might trade at 10x or 15x.
Okay, so why are venture capital firms like Tier 1 firms investing at these astronomical multiples?
The hunch driving this market, according to the analysis, is that this is a proxy maneuver.
A proxy for what? What are they actually betting on?
They are betting on OpenAI.
Wait, OpenAI?
Specifically, they are maneuvering to secure equity in the anticipated $1 trillion IPO of OpenAI.
Whoa. Wait, so you're saying the VC firms think OpenAI will eventually acquire Harvey using stock before OpenAI goes public?
That's the industry rumor the dossier points to. It's a proxy play.
That is wild.
The venture capitalists are buying into Harvey at inflated prices to get a backdoor ticket to the OpenAI IPO.
So it's not even really about Harvey's software. They don't even care if it works.
It's a macro AI financial bet. And the danger there is obvious. If that IPO catalyst fades, if the market cools, or if OpenAI decides they don't actually need to acquire Harvey because they can just build their own legal tools.
Like they easily could.
Right. This entire vertical SaaS bubble in legal tech could pop overnight.
Yeah.
The valuation isn't based on the software's fundamental unit economics.
Okay, I hear the dump skepticism. You're painting a very precarious picture, but I'm going to play devil's advocate for a second here.
Go for it.
Even if the valuation is inflated by proxy bets, you cannot ignore the sheer size of the serviceable available market.
The SAM.
Right, the SAM. The demand for legal work is exploding. I mean, the dossier points out that the U.S. employment and labor law sector alone represents a $9.7 billion market for generative AI.
And why is it growing so fast?
Because we are seeing a 50% year-over-year increase in systemic employment discrimination lawsuits filed by the EEOC.
It's a huge surge.
Surging litigation means surging demand for legal labor. Law firms are drowning in paperwork, discovery, and case law research. So, from my perspective, investing in an AI tool that can read and write legal documents right now, it's like selling pickaxes during a gold rush. The gold is there.
It is exactly like selling pickaxes during the gold rush. But as the dossier meticulously proves, these particular pickaxes are currently made of glass.
Made of glass.
Yes. They look beautiful in the store window, but they shatter the moment you hit solid rock.
Okay, you have to explain the glass pickaxe. What is the fundamental flaw?
The core problem, the reason this is all causing so much hidden friction, is that vanilla, general-purpose large language models are an absolute disaster for the actual rigorous practice of law.
We're talking about hallucinations, right?
Yeah.
The AI just making things up.
We are talking about severe, legally actionable hallucinations.
Right.
This isn't just a quirky AI generating a picture of a cat with 6 fingers. This is an AI inventing federal statutes.
That's terrifying.
The dossier cites Stanford research showing that general LLMs error on 69 to 88% of legal queries.
Up to 88%. That's not a tool, that's a liability.
And this isn't just an academic concern in a lab. Remember the story we opened with? The $86,000 sanction.
Yeah.
Public databases have logged over 1,490 global court cases where attorneys actually submitted AI hallucinated citations to a judge.
See, if you're a listener who isn't a lawyer, you have to understand submitting a fake case to a judge is one of the gravest ethical violations you can commit.
It's fraud on the court.
It is career-ending.
It fundamentally undermines the justice system. It has led to over $55,000 in cumulative U.S. sanctions so far, just based on the ones we know about.
Just the ones called.
Exactly. In most industries, say, marketing, if the AI hallucinates a slightly wrong statistic in a blog post, your tolerance might be 5%.
Right, you just fix it in post.
Exactly. In law, your hallucination tolerance is 0.0%. A single broken citation voids the entire deliverable.
So if I'm a managing partner and I know the AI I just bought for $1 million hallucinates up to 88% of the time, what do? How do I fix it?
You do what law firms have always done. You throw highly paid human labor at the problem.
The human safety net.
And this is where the dossier exposes what it calls the 13x physics gap.
Walk me through the physics gap, because that term is fascinating.
Because the AI is fundamentally untrustworthy, firms cannot just take the AI's output and send it to the client.
Obviously not.
They have to manually verify every single citation the AI generates. The dossier breaks down the granular economics of this for a typical mid-market firm execution. And if you have a pen, you might want to write these numbers down because they are staggering.
I'm ready.
A single complex legal execution using current AI costs the firm $11,180.83.
$11,000.
Yeah.
Just to execute one matter with AI.
Yes.
Break that down for me. Where's the money going?
Let's trace the life cycle of a document. First, intake and scoping. Figuring out what to ask the AI.
Prompt engineering, basically.
Right. That costs roughly $600 in billable time. Then the primary research phase prompting the AI, massaging the output, costs $3,350.
Okay, so we're at about $2,000. That's not terrible.
But now the safety net kicks in, the manual citation verification.
Okay.
A junior associate has to take the AI draft, log into Westlaw, and physically hunt down every single case the AI cited to make sure it actually exists and says what the AI claims it says.
Oh, man.
That manual verification costs $700.
And what happens when they find a fake case?
Oh.
Because we know they will.
This is the killer. They inevitably find hallucinated or misapplied cases. So the junior associate essentially has to rewrite the brief.
From scratch.
That junior rework cycle, fixing the AI's mess, costs $1,800.
Wow.
And finally, the senior partner, who is terrified of being sanctioned, knows the AI is risky. So they refuse to just skim it.
Right, they can't trust it.
They spend an hour and a half doing a deep substantive sign-off, which costs the firm $12,275 in partner time. Add it all up, plus overhead, and you are north of $11,000.
Oh, wow. So the promise was that the AI drafts the memo in 10 seconds.
And it does.
But the human safety net you have to wrap around that 10-second draft takes hours and costs thousands of dollars.
Exactly. It completely negates the speed.
And here's the psychological angle that really stuck out to me in the dossier, and I think anyone managing a team will relate to this.
Yeah.
Junior associates aren't stupid. They know they're the ones on the hook if the partner catches a fake case.
Oh, absolutely. It's their head on the block.
So what do? They don't even trust the AI to begin with.
Hmm.
Often they generate the AI draft just to satisfy the firm's mandate to use the new tech, and then they secretly ignore it and do the research from scratch on Westlaw anyway.
Yes. It's a dual-track workflow. They're doing double the work.
Exactly.
But here is the most insidious part of the 13x physics gap. How do they bill that time?
Oh, good question. How do they?
They don't have a billing code for fixing broken AI.
No, I doubt clients would pay for that.
The firm's timekeeping systems just absorb all this redundant, paranoid labor as generic review or analysis time.
So it's structurally invisible.
Yes.
The law firm CFO is looking at a spreadsheet, seeing review time, and has absolutely no idea that the firm is bleeding money just to verify the software they just bought. It's an invisible rework tax.
It is completely invisible to the C-suite. They think the AI is working perfectly because the deliverables are going out the door. They don't see the frantic 2 a.m. manual verification happening in the trenches.
That alone is a massive indictment of the current state of legal AI. But as the dossier shows, the labor bottleneck isn't even the only problem, right? The hardware and software constraints are just as brutal.
They're arguably worse. We mentioned ABA Model Rule 1.6 earlier. That's the American Bar Association mandate requiring strict client confidentiality.
Right. For those outside the industry, you cannot take a highly confidential Fortune 500 pre-merger agreement and just dump the text into public ChatGPT.
You absolutely cannot. If you do, you waive attorney-client privilege and you can be disbarred.
Not ideal.
So AI vendors targeting law firms can't use shared public clouds. They have to deploy dedicated, physically isolated GPU compute clusters inside highly secure virtual private clouds, or VPCs.
And GPU's graphics processing units are the incredibly expensive chips that run these AI models.
Exactly. For a company at Harvey scale, managing multi-terabyte document vaults and processing 700,000 daily tasks for paranoid law firms.
Right.
The dossier estimates that maintaining this dedicated, isolated GPU infrastructure costs between $10 million and $40 million annually.
$40 million a year just on the server costs to keep the data isolated.
Yes, and that's just the hardware. Then you have the human capital cost of integrating it.
Oh boy.
Let me ask you, have you ever heard of a forward deployed engineer or an FDE?
I have, actually. I know Palantir, the defense contractor, uses them a lot. It's an engineer who basically embeds with the client, right?
Exactly. You can't just give a 100-year-old law firm a login and password and say, have fun, here's your AI.
No, their IT is probably a mess.
Legacy law firm data is a nightmare. It's siloed in ancient document management systems, disorganized, and riddled with permission access issues. So AI companies have to embed these FDEs directly inside big law firms for 6 to 9 months at a time.
What are they actually doing for 9 months?
Their job is to map the firm's tribal workflows, bypass deeply resistant senior partners, clean the data, and rebuild the firm's specific knowledge base into the LLM so it actually understands how the firm operates.
Wow.
They are essentially digital diplomats and data plumbers combined.
And I imagine, given the AI boom, they do not work for cheap.
They have become the highest paid generalist role in all of artificial intelligence.
Really?
According to the data, a mid-level FDE today commands a median total compensation of $385,000.
Well, that's a lot.
But if you want a staff or principal FDE, the ones who can actually navigate the politics of a big law partnership, they clear anywhere from $750,000 to over $1.2 million annually.
Over $1 million a year for an integration engineer.
Yes, because they aren't just IT support, they are acting as the revenue retention function.
Meaning?
If the FDE doesn't successfully integrate the tool and force the lawyers to use it, the law firm cancels the $1 million contract. The FDE is the only thing keeping the churn rate from hitting 100%.
Okay, so we have tens of millions in hardware costs, $1 million deployment engineers, and we haven't even touched the regulatory side.
The regulatory side is a looming nightmare. If a law firm touches the European market in any way, they have to comply with the EU AI Act.
Right.
The dossier notes that initial compliance implementation for this runs between $90,000 and $265,000. And if you mess up a high-risk system, which legal AI absolutely is, the fines can reach 35 million euros, or 7% of your global turnover.
That is steep.
Then add in mandatory SOC2 Type 2 security audits, which cost up to $200,000 in just the first year.
Okay, I have to stop you. I'm trying to put myself in the shoes of a buyer.
Sure.
If the hardware costs tens of millions, if the regulatory burden is crushing, if the software hallucinates and requires hours of invisible rework, and if it requires literal million-dollar engineers to install.
Yeah.
How on earth did Harvey and these other companies convince law firms to buy it in the first place? How do you sell a product with that much baggage?
This is where the pricing strategy is, frankly, genius. They used a very specific psychological SaaS pricing trick. If the AI vendors had gone to the law firm's chief information officer and said, we need a multi-million-dollar IT budget to overhaul your entire infrastructure, the CIO would have laughed them out of the room.
Right. IT budgets are notoriously tight. They guard every penny.
Exactly. So they didn't go to IT. They completely bypassed the CIO.
Who did they go to?
They went straight to the managing partners.
The people who care about profit per partner, not server architecture.
Yes. They framed the $1,200 per seat annual cost not as a technology expense, but as a labor substitute.
Oh, that's smart.
They pitched it by saying, look at your junior associates. You are paying them hundreds of thousands of dollars a year. This AI software costs $1,200 a year. That represents a mere 5 to 7% of a single junior associate's labor costs.
Wow.
If this tool saves them even 1 hour a week over a year, it pays for itself infinitely.
By framing it as a micro fraction of human capital, it feels like a no-brainer.
It bypasses the traditional IT scrutiny entirely. It's an incredibly seductive pitch. But this brings us to the operational reality of what happens when that seductive pitch hits the real world.
And this brings us to what I think is the most mind-bending plot twist in the entire venture-proof dossier.
It really is.
Because if you're listening, you might be thinking, okay, the AI is flawed, it requires rework, but surely it's still replacing some human jobs, right?
Right, that's the logic.
Here's where it gets really interesting. Economists, analysts, tech pundits, everybody predicted that when AI could finally draft contracts and summarize case law in seconds, it would destroy the billable hour.
That was the consensus.
It was supposed to shrink law firms, drastically reduce associate hiring, and collapse the traditional leverage pyramid where partners make their millions off the backs of junior associates' hours.
It's the classic automation narrative. You introduce the robotic arm, you fire the manual welder.
Exactly. But the exact opposite happened in law. The opposite.
Yeah.
And the dossier explains this phenomenon through a brilliant economic concept called the Jevons paradox. For our listeners who haven't taken a deep economics dive recently, have you run across William Stanley Jevons before?
I have. 1860s, right. The coal industry.
Yes. So 1865, England, William Stanley Jevons observes the introduction of the James Watt steam engine.
Right.
This new engine was massively more efficient than the old ones. It used way less coal to do the same amount of work. So logic dictates that England's overall coal consumption should go down, right? Because they are being more efficient.
But that's not what happened.
No, they used exponentially more coal. Because steam power was suddenly so cost-effective and efficient, they found a million new applications for it. They put engines in factories, trains, ships.
The efficiency created its own demand.
The efficiency made the resource cheaper, which caused aggregate demand to completely explode. The dossier argues this exact same paradox is restructuring the legal profession right now.
Let's walk through exactly how that maps to legal services. How does AI act like the Watt steam engine?
Okay, think about the marginal cost of analyzing a legal document. Before AI, it was incredibly high because a human had to physically read it.
Right, line by line.
Suddenly, because of AI, that marginal cost plummets to near zero. So workflows that were completely ignored before because they were too expensive suddenly became economically viable.
Give me an example of an ignored workflow.
Think about a massive corporation that just got acquired. They want to do a historical sweep of 10,000 old non-disclosure agreements to check for a specific, obscure compliance risk.
Okay.
Before AI, paying lawyers $500 an hour to manually read 10,000 NDAs was financial suicide.
It would cost millions.
The client would just say, don't bother, we'll accept the risk.
Yeah.
But with AI, you can run that entire sweep in an afternoon.
So latent demand is suddenly unleashed. The client says, wait, if it's that cheap, yes, analyze all 10,000 documents.
Exactly. The total volume of legal work being executed expanded massively. The pie got bigger.
Which explains the hiring.
Yes. Because of this massive influx of new micro tasks, associate hiring at law firms remained totally robust. In fact, the Kravitz scale, which is the benchmark base pay for first-year lawyers at elite firms, didn't go down.
It went up.
It actually reset upward in 2026 to $235,000 base pay for a 25-year-old. The AI didn't replace them. It just gave them a fire hose of new tasks to manage.
And this paradox doesn't just affect the economics of the law firms. The dossier points out it is fundamentally straining the physical infrastructure of the AI industry itself.
Yes, the microinteraction explosion. This is fascinating because computing a single token a piece of a word is practically free. AI is getting embedded into every single layer of software.
Everywhere you look.
You type one prompt into a legal drafting tool and you think you're just doing one query. But in the background, it triggers hundreds of recursive, hidden agentic loops.
Behind the scenes.
The AI is querying a database, checking conflicts, rewriting sentences, cross-referencing files, all without you knowing.
This extreme drop in unit costs has triggered infinite volume scaling.
Which is exactly why the hyperscalers, the Microsofts, Googles, Metas, and Amazons of the world, are being forced to commit a cumulative $650 billion to AI capital expenditures in 2026 alone.
$650 billion.
They're building data centers so fast, it is literally straining global power grids.
It's wild, but I have to throw a massive skeptical caveat into this Jevons paradox theory.
Go for it.
The Jevons paradox in the context of law has a catastrophic trapdoor.
A trapdoor.
The dossier calculates the elasticity factor of this new demand at 1.5.
Break that down. What does an elasticity factor of 1.5 mean in plain English?
It means that for every dollar a law firm saves on manual verification through efficiency, they generate about 50 cents of new demand. New legal matters, new massive document audits.
Okay, that sounds good for business.
But we have to remember the rule we established earlier, the 0.0% hallucination tolerance.
Right. The AI still hallucinates, so it can't be fully trusted.
Exactly. So think about the workflow. The junior associates are using AI to churn out drafts and analyze those 10,000 NDAs at 10x speed. But who has to review the final output before it goes to the client? Who takes the ultimate legal risk?
The senior partners.
Yes. All this newly generated AI-induced demand floods straight to the top of the pyramid. The junior associates are moving at light speed, and the senior partners, who are still human, who still read at a human pace, are getting absolutely crushed under a tidal wave of review work.
Oh, man.
As the dossier puts it so perfectly, it's like widening a highway by 2 extra lanes, only to realize the off-ramp is still a single dirt road.
Oh, there's a brilliant analogy. The partners are the single dirt road.
Exactly.
The cognitive bottleneck didn't disappear. It just moved from the bottom of the firm to the top.
Precisely. And human partners do not scale. You can't just buy more of them.
So how does the industry solve this? Because if the partners burn out, or if they just rubber stamp AI work and get sanctioned, the whole leverage model of the law firm collapses.
This is where we get to the core insight of the entire venture-proof analysis. The realization that the underlying large language models, the actual neural networks that everyone is so obsessed with, are no longer the competitive moat.
Because everyone has a good model now. It's commoditized.
Exactly. The dossier points out that Harvey actually abandoned maintaining its proprietary, custom-built, vertical legal model.
Why? I thought that was their whole thing.
Because once OpenAI's GPT-4 and Anthropic's Claude 3.5 achieved performance parity on standard legal benchmarks, spending millions to train a custom model became pointless.
It's just burning cash.
Trying to compete on the neural network itself became a dead end. The real moat isn't the model, it is the data.
Which brings us to RAG, Retrieval Augmented Generation.
Right.
So if throwing a better, bigger neural network at the problem doesn't stop the hallucinations, how do you ground the AI? You have to take away its ability to guess entirely, right?
Correct. The industry realized that if you want to stop the AI from hallucinating a court case, you can't just ask the model to predict the next most likely word based on its training data.
Because that's how it makes things up.
You have to tether the AI to pristine, editorially enhanced proprietary databases. You force the AI to look up the answer in a trusted source, read it, and then speak. That is RAG.
And this data tethering is why Clio, which is a massive practice management software giant, just dropped $1 billion to acquire VLEX.
Exactly.
They didn't buy an AI model. They bought a proprietary database of over 1 billion legal documents across 100 countries. It's a data sovereignty arms race.
Precisely. The Jevons paradox unexpectedly entrenched the legacy data monopolies.
Right.
Everyone thought AI would kill companies like Westlaw and LexisNexis because the AI would just know everything. Instead, because AI hallucinates and courts sanction lawyers for it, the AI must be fed pristine data.
So the data providers got more powerful.
RAG made text easier to extract, which ironically made access to the highest quality text exponentially more valuable.
Okay, so they need the data. But how does that solve the partner bottleneck? How do we widen that dirt road?
This brings us to what the dossier calls Pathway C, agentic inversion.
This is the ultimate architectural solution to that 13x physics gap we talked about.
Break down the pathways for the listener so we understand why C is the breakthrough. What were A and B?
So pathway A was the default SaaS strategy. Just sell the same broken AI to more personas. If the law firm partner is bottlenecked, try selling the tool directly to the client's general counsel.
But that doesn't fix the underlying friction.
No, it just moves the hallucination risk to a different desk.
Right, sweeping it under the rug.
Pathway B was trying to build tools that make the manual review slightly faster. Better highlighting tools, faster search.
But that's also a dead end.
Exactly, because of the Jevons rebound. If you make review 10% faster, the firm just generates 20% more documents, and you're back to square one.
So what is Pathway C? What is agentic inversion?
Pathway C is a total paradigm shift. It's the blueprint for a system the dossier calls Veritas Lex.
And what does Veritas Lex do differently than a standard AI chatbot?
It generates a citation provenance receipt as a byproduct of the drafting itself. The core insight, and this is the big aha moment of the dossier, is that you shouldn't use AI just to draft the document. You should use AI to prove the document is real.
AI that proves, not just AI that drafts.
Exactly. Think about how a lawyer works today. They draft a document, and then a junior associate goes back through it, manually building a chain of evidence to prove every citation is valid.
The manual hunt?
Agentic inversion flicks that.
Yeah.
With Veritas Lex, every single citation the AI generates is instantly linked to a cryptographic hash of the primary authority, the actual original court opinion or statute.
Wow.
The provenance chain isn't something a human builds manually after the fact. It is baked into the document mathematically from the very first keystroke.
If we connect this to the bigger picture, this is a profound architectural shift. It moves from probabilistic guessing to mathematical certainty. But we need to get into the weeds on how Veritas Lex actually works mechanically, because the defensibility of this whole concept lies in the architecture.
Let's do it. Take us through the mechanics. How do we build this?
First, the architecture relies on a deterministic citation graph engine.
Let's translate that.
Yeah.
Deterministic, not probabilistic.
Right. General LLMs are probabilistic. They guess the next most likely word based on statistical weights.
Which is great for poetry, bad for law.
That's why they are creative, but it's also why they hallucinate. Veritas Lex strips away the probability for the verification step. It uses a deterministic XML graph database of court opinions.
Okay.
It doesn't guess. It performs an exact Boolean algorithmic match against the actual byte stream of the legal corpus. It's binary. It's either there or it's not.
It essentially looks it up in a massive structured index.
It looks it up and mathematically proves it exists. But here's the massive vulnerability the dossier highlights, and it's a huge one-vendor eviction.
What's vendor eviction?
If your deterministic engine relies entirely on, say, Westlaw or LexisNexis for this pristine data, what happens if Westlaw decides they don't like you?
Oh.
What if they hike their API prices by 300% overnight? Or what if they cut off your access entirely because they want to build their own competing AI? If you rely on one vendor, your tool dies instantly.
You're completely at their mercy. So how does Veritas Lex survive that threat?
Through something called multi-vendor citator API federation.
Okay, I need an analogy for this one.
Think of it like an investigative journalist trying to verify a controversial story. If the journalist only has one source, and that source suddenly refuses to talk, the story dies.
Right.
But if the journalist has a network of 5 different sources, they just call the next one. When the Veritas Lex AI needs to verify a citation, it doesn't just ask one vendor. It orchestrates parallel queries across Westlaw, LexisNexis vLex, Bloomberg Law, and Fastcase simultaneously.
It interrogates everyone at once.
Exactly. It federates the query. And it is built with explicit graceful degradation. If Westlaw tries to throttle the API, the system seamlessly shifts the load to Lexis. But even better, if all the commercial vendors collude and throttle access, the system falls back to a public open access bindingness mirror.
What is that?
This is a mirror built from Pacer, Recap, and state core open access rules.
So it always has a backup.
It converts vendor eviction from an existential threat into a mere contractual negotiation. Because if the incumbents try to throttle the AI just routes around them, and the incumbent loses the API revenue, it completely neutralizes their monopoly power.
That is incredibly resilient engineering. And the beauty of this is, from the lawyer's perspective, they don't see any of this chaotic data federation happening in the back end.
No, not at all.
They don't need to know what an API or an XML graph is. They just use a simple Microsoft Word or Google Docs add-in. They're drafting their brief, and the AI injects a little inline confidence score next to every citation.
A green light.
If they see a green verdict, it means that citation is real, it's accurately applied, and it is legally binding at that exact millisecond.
Which completely eliminates the need for the junior associate to spend 3 hours manually hunting it down on Westlaw. The physics gap is closed.
Exactly. But the most exciting part to me, the part that turns this from a cool tool into a foundational enterprise asset, is the ledger.
The DUAL.
Yes, the DUAL, the Defensible Output Attribution Ledger.
Unpack the DUAL for us. I'm looking at this acronym, and my understanding is this acts almost like a black box flight recorder for the document. Am I looking at that right?
You are spot on. That is exactly what it is. Every single time the system verifies a citation, it creates an immutable worm audit trail.
Worm.
Worm stands for write once, read many, meaning it cannot be altered or tampered with after the fact. It timestamps the exact millisecond of verification, it links the cryptographic hash of the primary court case, and it records exactly which human reviewer approved it.
Okay.
And this sidecar file doesn't sit on a public server. It sits directly inside the law firm's sovereign document management system, like iManage or NetDocuments. It creates a permanent, untamperable defense dossier for every single brief.
Okay, wait. I have to push back here. This raises a massive, glaring privacy question.
Bring it on.
If you are federating all this data across APIs and building this massive matrix of which citations work and which don't, aren't you aggregating highly confidential client data?
A valid concern.
Doesn't this violate ABA Rule 1.6 on privilege that we talked about earlier? If I'm a Fortune 500 CEO going through a merger, I do not want the specific, highly privileged details of my merger feeding a global AI brain just to verify a citation.
And this is why the architectural design in the dossier is so bulletproof. They anticipated that exact pushback. The architecture uses federated MPC and K-anonymized ledgers.
Okay, you need to explain federated MPC, multi-party computation. How does that protect the data?
Think of federated MPC like a bouncer at a very exclusive club. When you hand the bouncer your ID, they need to verify you're over 21, but they don't need to know your home address, your weight, or your organ donor status.
Right.
A cryptographic bouncer can verify the truth of your age without ever exposing the rest of the data.
So how does that apply to the legal brief?
The AI and the DOAL ledger only process the citations themselves. The system computationally strips away all the surrounding privileged text of the legal brief before the data ever leaves the firm's sovereign server perimeter.
Oh, I see.
It's just extracting the blue book citation string, the name of the case and the volume number, and sending that to the bouncer to get a Boolean true-false verification status. The client secrets, the merger details, the strategy, none of it ever crosses the wire.
That is a crucial distinction. It protects attorney-client privilege, absolutely, while still building the network effect of knowing which citations are solidly verifiable.
Exactly.
So we've established the architecture. Let's look at the actual financial results of implementing this agentic inversion. Earlier, we talked about the manual execution cost being a staggering $11,180.83 per matter.
Right, the 13x physics gap. So what happens when a firm uses Veritas Lex instead?
By utilizing this machine-grounded provenance and completely eliminating those manual verification loops and the junior rework, the optimized physics floor drops from over $11,000 down to just $892.19 per execution.
That is insane. That is a 13x cost reduction.
It is.
But it's not just about saving money on one case, is it? The dossier scales this up.
It does. The analysis totals up the strategic value of this architectural shift across a modeled footprint of just 15 enterprise accounts.
Okay.
Assuming about 2,280 annual legal executions across those firms, and it breaks the value down into 3 distinct legs.
Okay, grab a pen, because the math we're about to walk you through completely breaks the traditional SaaS model you're used to.
It does.
Leg number 1. Direct OpEx reclaimed. By eliminating the manual verification tax, the paralegal time, the junior rewrite, the endless partner review, the firm saved $23.45 million annually. That is straight operational waste reclaimed.
That's a huge number, and that's the number most SaaS companies focus on. But the second leg, the dossier models, is even bigger. Pipeline value preserved.
What does that mean in this context? Pipeline value.
Let's focus on the human story behind the numbers. The dossier found that firms currently abandon roughly 15% of generative AI engagement.
Really, 15%?
Why? Because the manual verification takes so long that deadlines are missed. Imagine a client needs an emergency injunction filed by tomorrow morning. The AI drafts it in 10 seconds, but the junior associate can't verify the 50 citations in time.
So they miss the window.
The deadline is blown. The client gets furious, they pull their business, and the relationship is damaged. Firms literally leave money on the table because they can't verify the AI output fast enough to bill for it.
Wow, so fixing this friction isn't just about saving associate time, it's about saving the client relationship.
Exactly. By providing instant cryptographic provenance, Veritas Lex preserves $95.59 million in relationship and pipeline value that would otherwise just walk out the door due to missed deadlines and friction.
That is massive. And then the third leg, captured high-margin fees.
Right.
Instead of selling a flat $1,200 seat license, the platform uses a value-based margin participating contract. They essentially take a 10% cut of the capacity they recover for the firm. That captures $9.55 million.
When you add all three legs together, the OpEx, the pipeline, and the fees, the total strategic value unlocked is over $128.6 million annually across just those 15 accounts.
It's a massive unlock. But you know what the most pragmatic, genius part of this whole dossier is?
What's that?
It's not the math. It's the go-to-market strategy. If you build this incredible, mathematically perfect system, you don't try to sell it to the firm's CIO.
Who do you sell it to?
You sell it to the managing partner.
Yeah.
More importantly, you sell it to the malpractice insurance carrier.
Because they hold the ultimate risk.
Exactly.
They're the ones who pay out when the partner gets sanctioned for an AI hallucination.
Yes. Think about it. The DOAL, that immutable ledger we talked about, acts as a pristine verification dossier. The system is so mathematically watertight that malpractice insurance carriers can look at it and offer 5 to 12% premium discounts to the law firm for using it.
That's a huge incentive.
Why? Because the firm can cryptographically prove they didn't hallucinate. If a client sues them for malpractice, the firm just hands the warm ledger to the judge and says, here is the exact timestamp, the cryptographic hash, and the primary source for every single claim we made.
That is brilliant. You are weaponizing compliance. You align the software with the one entity that has the financial leverage to force a stubbornly traditional law firm to change its behavior, the insurance underwriter.
Exactly.
If the insurer says, use this tool or your premiums double, the firm uses the tool.
Exactly. Which leads us to the final long-term legacy of this shift. We aren't just talking about a better software tool anymore. We are talking about re-architecting law firm economics from the ground up.
The big picture.
Currently, verification is what the dossier calls extraction economics.
Explain extraction economics, meaning value flows from the worker to the firm and then dissipates.
Right. Let's say Sarah, a junior associate, spends an hour shepherdizing a complex case, making sure it's still good law.
Okay.
She bills that hour to the client, the firm makes a profit, and then that value evaporates. It's gone.
What do you mean it's gone?
The next month, when another partner in a different office needs that exact same case law verified, they have to pay a different associate to do it all over again from scratch. It's a depreciating consumption event. It's incredibly inefficient.
So how does the Veritas Lex architecture change that?
It turns verification into a compounding asset. The dossier recommends something revolutionary: paying the verifiers, the junior associates who do the final human-in-the-loop, checks on complex new legal theories. A residual.
A residual, like an actor gets for a television rerun.
Exactly like that. Imagine this. Sarah verifies a complex novel citation chain using the AI. Because it's verified, it gets logged into the firm's persistent vector store, their internal AI brain.
Right.
That citation chain is now a verified asset. If that exact citation chain is pulled and reused in a future matter by someone else in the firm, Sarah gets a 5 to 15% residual of the downstream realization.
What's fascinating here is that you are fundamentally changing the psychological incentive structure of a law firm.
You really are.
You are turning junior associates who traditionally just grind out billable hours into intellectual property royalty earners.
Okay.
They aren't just billing time anymore. They are building equity in the firm's automated knowledge base.
Yes. It incentivizes them to do the verification perfectly the first time. They want to find the hardest, most complex legal arguments and verify them. because they want those arguments to become a permanent, reusable asset that pays them dividends while they sleep.
And from a vendor perspective, if you are the company selling Veritas Lex, this creates incredible switching gravity.
Switching gravity, I love that term.
Yes, think about the moat this creates. If a law firm decides after 5 years that they want to cancel their Veritas Lex contract and move to a slightly cheaper competitor, they don't just lose a software interface.
No.
They lose their cryptographically signed malpractice defense history. They lose the compounding internal knowledge base that is actively paying their associates residuals.
Wow.
The cost of leaving becomes astronomically higher than the cost of staying. The lock-in is structural, it's economic, and it's cultural. It's an impenetrable moat.
It really is. Okay, let's take a breath and recap this incredible journey we've been on today. We started with the hypergrowth illusion of LLMs in law, the FOMO-driven bubble, where AmLaw 100 firms were blindly throwing millions at opaque seat licenses just to say they had AI.
Then we hit the hallucination-driven physics gap, where the hidden costs of manual verification, the $11,000 price tag for a single execution, was secretly bleeding firms dry, entirely invisible to the CFOs.
Then we explore the Jevons paradox, where we realized that cheaper, faster AI didn't destroy jobs. It actually exploded demand, created a fire hose of new legal work, and caused a catastrophic cognitive bottleneck at the senior partner level, the dirt road off-ramp.
And finally, we arrived at the architectural solution pathway C, agentic inversion. Moving from probabilistic AI that just guesses and drafts to deterministic AI that mathematically proves its work using federated data APIs and immutable ledgers, ultimately unlocking $128 million in value and turning manual junior labor into compounding intellectual equity.
It's a masterful, granular deconstruction of a sector in transition. But as we wrap up, I know you always look for the ripple effect. What is the ultimate takeaway here?
If we connect this to the bigger picture, it leaves me with a lingering, almost unsettling thought. We've spent this entire deep dive looking at the legal profession. But if cryptographic provenance, this immutable agentic verification, becomes the gold standard mandated by malpractice carriers in law, how long until this exact same architecture is legally mandated for every high-stakes profession?
Oh, wow. I see where you're going.
Think about medicine. A doctor making a complex diagnostic decision.
Yeah.
Civil engineering. An engineer signing off on the load-bearing capacity of a bridge. Financial auditing. If a machine can cryptographically prove its reasoning step by step, drawing from a federated API of pristine medical or engineering data, and a human can't, will we soon live in a world where no human decision is trusted by courts, by insurers, by society, unless it is backed by an automated, immutable provenance receipt? Are we entering an era where relying on human judgment alone without a cryptographic ledger to prove your work is legally considered negligent?
That is a heavy and entirely plausible future. It's the X-ray machine for human decision-making. Once you have it, you can't ever go back to just...
Exactly. You can never go back.
Well, on that provocative note, we want to thank you for joining us on this Innovation Unpacked deep dive into the venture-proof analysis. We encourage you to look at your own industry, your own workflows, and ask yourself, where are the invisible physics gaps hiding in your organization? Are you trapped in extraction economics? And most importantly, are you building tools that just draft faster? Or are you building tools that actually prove their work? Until next time, keep unpacking the future.